So the headlines for this story have been great. Animals recognized as legal persons for the first time in U.S. court. In the 1980s, Colombian drug trafficker Pablo Escobar purchased 4 hippopotamuses for his private zoo. After Escobar's death, the Colombian government left the hippopotamuses on his property because it was unable to transport them to a suitable environment. In the years that followed, the hippopotamuses escaped the property, relocated to the Magdalena River, and reproduced at a rate that some ecologists consider to be unsustainable. Maybe we could call them horny hippos. Today, a group of scientists and government officials who are concerned about the hippopotamuses' overpopulation have proposed that the animals be killed. I'm going to use the word culled. I'm sure the Animal Legal Defense Fund has a preference there, but we do, as a society, generally cull animals that are overpopulated. And my philosophy on that is that it is actually better for everyone because there's less problems for the ones that remain and there's less suffering amongst the animals. But reasonable people could disagree. To prevent their slaughter, Colombian attorney Luis Domingo Gomez Maldonado has filed a lawsuit on behalf of the community of hippopotamoi. The case, which is still ongoing, was filed before the Administrative Tribunal of Cundinamarca on July 31, 2020. The lawsuit demands that the government use non-lethal birth control to manage the size of the community's population. After the lawsuit was filed, a group of wildlife specialists announced that they had developed a plan to use immunocontraception, a form of non-lethal birth control, to prevent the community from overpopulating. To confirm and prove that the plan is a workable alternative to lethal force, the community need to collect the testimony of its 2 proponents, 2 of whom reside in this district, the Southern District of Ohio, in the United States. Dr. Elizabeth Berkeley, MS Ph.D., and Dr. Richard Berlinski, DVM, so a veterinarian, reside in the Southern District of Ohio. They specialize in wildlife immunocontraception and exotic animal medicine, respectively, and are part of the group of wildlife specialists who would implement the plan. As such, their deposition testimony is critical to the success of the Colombian litigation. So what we're looking at here then is an ex parte, which means without an opposing party, an application of the community of hippopotamuses who are listed as the plaintiffs. Normally you have human plaintiffs. Here you have hippopotamoi as plaintiffs. Living in the Magdalena River, they want an order pursuant to 28 U.S.C. section 1782 to conduct discovery for use in foreign proceedings. The request for depositions is vital to the success of the community's litigation in the Republic of Colombia, where they are the plaintiffs. The requirements of the law are met. The doctors live in this county, thus they both reside or are found in this district. Their deposition would be presented to the court as evidence, making it for use in a foreign tribunal. And the community are the plaintiffs in the Colombia litigation. Therefore, they qualify as interested persons under the statute. So the headlines for this story have been great. Animals recognized as legal persons for the first time in U.S. court, which I don't know if it's the first time, but it certainly sounds like it could be under this particular law. And so the Animal Legal Defense Fund has written this article that the animals have now been recognized as interested persons, saying, today, the Animal Legal Defense Fund announced that the U.S. District Court for the Southern District of Ohio has recognized animals as legal persons for the first time in the United States. In pursuit of deposing the wildlife experts, the Animal Legal Defense Fund filed an application on behalf of 100 hippos who are descendants of the animals imported by Pablo Escobar. What did I say, 4 in the beginning, and now they've multiplied to 100. So yeah, something needs to be done. Hippos are very dangerous and can be very aggressive animals. And I'm assuming that these not domesticated hippos kept by Escobar need some kind of care or looking after. So I'm assuming that that's why there is someone trying to do like a sort of catch and release program like we do with wild cats and dogs in the US, or stray cats and dogs or outdoor cats and dogs. Get your pets neutered and spayed, people. I mean, this is not just something we say on The Price is Right. This is really a good thing. Even I have had to learn over the years why you do or don't feed stray animals. Yes, you want to alleviate their suffering, but then there's this knock-on effect. If you feed stray cats and it becomes something they become dependent upon and start having more cats, because look at the excess of resources that they have access to, then you have more cats, and then you have potentially more suffering when those cats can't all get to food. That's maybe not dependable because someone just feeds them once in a while. So it has to be part of like a plan to catch and release an animal. You catch them, bring them for spay or neuter. Your local county will usually have a humane society or some sort of animal control that will participate in a free or low-cost spay and neuter program for these cats and dogs, and then you take them back to their home and you release them back to their home, and now they can't reproduce and create further suffering down the road. It's certainly something that reasonable people can debate how it should be done, but please consider getting your animals spayed and neutered so we make sure to minimize any suffering, because here's what happens. You now have 100 hippos on the Magdalena River who need looking after. The plaintiffs are a community of hippopotamuses living in the Magdalena River. In Colombia, animals have legal standing to bring lawsuits to protect their interests. In granting the application pursuant to U.S. law to conduct discovery for use in the foreign proceedings, the court recognized the hippos as legal persons with respect to that statute. So, of course, I just spoiled it, but the court has now granted this interested person's standing. Upon consideration of the ex parte order, writes Judge Litkovitz, I think it is, the order is granted. Counsel for the applicant is authorized to issue the subpoenas. The court shall retain jurisdiction as is necessary to effectuate the terms of those subpoenas. And that just happened in the middle of October. So let's take a quick look at what the actual law says. Section 1782, titled Assistance to Foreign and International Tribunals and to Litigants Before Such Tribunals, is the product of 150 years of congressional efforts, so that means legislation, to ensure that federal courts assist with gathering of documents and testimony for use in foreign tribunals. To invoke Section 1782, an applicant must satisfy 3 statutory prerequisites. 1, the person from whom discovery is sought resides or is found in the district of the district court to which the application is made, so that's sort of location or venue. 2, the discovery sought is for use in a foreign proceeding before a foreign tribunal. And 3, the application is made by a foreign or international tribunal for any interested person. Courts evaluate these prerequisites in light of the statute's increasingly broad applicability so as to encourage foreign countries, by example, to provide similar means of assistance to our court. If these threshold factors are met, courts consider whether to grant an application by applying discretionary factors outlined by the Intel Corp case. 1, whether the person from whom discovery is sought is a participant in the foreign proceeding, and 2, the nature of the foreign tribunal, the character of the proceedings, the receptivity of the tribunal to federal court judicial assistance, and whether the application conceals an attempt to circumvent the foreign proof gathering restrictions or other policies, or whether the request is unduly burdensome. So they're going to argue that these doctors are found here, they are part of the foreign tribunal, that the plaintiffs are interested persons. And so the remarkable thing here is that the court has granted a bloat of hippopotamuses, a community, a group of hippopotamoi, the right to be represented in this U.S. court and get this subpoena. So I think that's remarkable. It's funny. We could call it horny hippos, but I don't think YouTube is going to let me get away with that in a YouTube thumbnail. So we'll have to find something else. But yeah, that's what's going on here. Is we have the Animal Legal Defense Fund trying to prevent the culling of these hippopotamoi, and there is a compromise. There is some kind of existing sterilization program, and I believe they're going to argue for a different, maybe arguably better sterilization program. I'm not familiar with what's good or what's bad. You'd have to talk to the doctor of veterinary medicine, Dr. Berlinski and the other doctor whose name I've forgotten. Yes, Dr. Berkeley and Dr. Berlinski. So that's interesting. That's fun. Let me know what you think in the comments below. Thanks for watching. Special thanks to our top supporters in November: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Join me for our weekly production live stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.